Quite often in law you hear about injuries that they say are traumatically caused or caused from a trauma. These are commonly known as injuries from a trauma or trauma-induced injuries. Gary, you're familiar with that term?
Right. And you know, we also apply that term to car crashes, collisions, slip and falls, premises liability. Anytime you're injured by, through a trauma, it can apply.
Why do you want to know if the injury was caused by a trauma?
Usually you're looking, if you're going to look to recover, you're looking to see if somebody was negligent, somebody didn't follow the rules, and therefore they caused your injury or injuries and all your damages and losses.
Do you try to separate out what degree the injury was caused by a trauma versus what might be from a natural consequence of just the aging process?
Of course, and insurance companies for at-fault parties always try to blame you because you have a congenital condition. You have a pre-existing condition. Sometimes they call it, well, you had degenerative disc disease. And you need to be able to separate out the medicine from exactly what happened in the trauma. You need to be able to prove what happened from the trauma as opposed to a natural aging process, as opposed to degenerative disc disease and those type of matters.
Let's say I'm at the scene of the accident or I'm at the scene where the injury has occurred. I believe I've got an injury that's caused by the trauma or the event that's occurred. What do I want to do concerning my medical care and treatment?
Look, you need to seek medical care and treatment. You need to take care of yourself. If you don't go to the doctor, simply put, the insurance company for the at-fault party, who is your enemy, they are not your friend, they're going to use it against you. They're going to say you never went to the doctor. They're going to say you never did follow-up care. You didn't do any prescriptions. You didn't have any diagnostic tests. And they will use these things against you. So if you're hurt, you don't want to make anything up because that haunts you later. You need to legitimately report all symptoms, everything that happened to you, and how it has affected your life.
What if I have very minimum amount of med pay, which we talk about in another segment, or it's in an accident where it's a slip and fall, and there's no med pay, and I'm worried about paying for the medical care?
Right, med pay applies to car accidents, so if you're in a trauma other than a car accident, med pay would not apply. If you don't have health insurance, there is a way. There are many ways to get you the medical treatment you need, even as far as surgery is concerned. Daily medical treatment, prescription medications, injections, surgery. You can get it and you can take care of yourself even if you don't have med pay or if med pay doesn't apply, and even if you don't have health insurance. Don't ignore the fact that you must seek medical treatment.
Well, okay, when I'm trying to get this treatment, this care, and I'm trying to preserve my rights, the insurance company for the other side is going to call me. What do I do about statements and medical releases? Do I give them to them?
You know, they do call you. Sometimes they want a statement. If you're foggy in your mind, if you've suffered a brain injury, a concussion, if you're confused, you probably don't want to give that statement immediately. You're not required to give that statement immediately. I want to point out to you, this insurance company for the at-fault party, not your insurance company, but the insurance company for the at-fault party is your adversary. They are your enemy. They are there to get information from you and give you very little information, if any at all. Therefore, you don't want to give them a quick statement. You want to think through, make sure you understand what happened in the accident or collision or the trauma or the slip and fall, and make sure you give a clear, concise, accurate statement. Sometimes they want to get a release have you sign a release so they can go get all your medical records. Under no circumstances should you do that just right away. They don't have the right to all your medical records for all your conditions in, say, the past 10 years, 15 years, but they'll ask for it, and you shouldn't automatically give it. There's a new case out called Alcon versus Spicer. This case holds by the Supreme Court that you don't have to give all these medical records. You only have to give the ones that are relevant to and pertinent to the injuries that you received from the trauma.
Well, what do I do with the medical release then? Do I just throw it away? Do I get the records for them? What should I do?
Sometimes you don't have to sign it at all right away. Sometimes your treatment is going to last weeks or months. They don't need to get your treatment records as you go. Some of these doctors take histories from you. They have questionnaires that you fill out. Did your family have a history of cancer? They don't need to know this. Did you have female gynecological problems? They don't need to know that, but they're going to get it. And the reason they're going to get it is they're going to try to use it against you because they're going to blame your injuries, your symptoms on anything but the accident, anything but the collision, anything but the trauma. So if you're confused or you need help, you can seek the services of an attorney to work on the release, and appropriate release you can and should give.
All right, let's say I'm giving a recorded statement. Are there some limitations or rules I should set down?
Sure. Most of the time they say, you know, we're going to record you on this statement. Do we have your permission? If you don't want to give your permission, don't do it. They're going to type it on their little computer anyway, and it's going to go into the record. But if you consent, and sometimes we do, let our clients give a recorded statement. Make sure your statement is thorough and accurate. Make sure you ask them to give you a copy of the recorded statement, and make sure you see the transcription of the recorded statement. You would not believe how sometimes the tape of the recorded statement doesn't match or jive with the transcript, and they will use it against you, even when it's in error.